Hey guys, good morning. Now today's time for this video shooting is morning 6 o'clock, and I am shooting this video early morning because I want to expand your knowledge about the Customs Act 1962. My only motive is that the importer, exporter, or custom broker should know the Customs Act 1962 via this YouTube channel because as a working professional, we don't have that much time to read the books. So we I, Mangesh Hande, creating the videos on the Customs Act 1962 about the customs clearance and importation and exportation of goods. So, guys, if you are watching my channel first time, if you are watching my videos first time, please subscribe to my channel so you will get the new videos on the customs and regarding the import and export. So, guys, in the previous videos, we have already seen up to the chapter number 14 from the Customs Act 1962. The Customs Act 1962 was built in 1962 year, and this come through the notification number 52 of the year 1962, and the implementation of the Customs Act 1962 had start from 1st February 1963. So, in the Customs Act, there is mentioned all the importation and exportation laws, provisions, what are the restrictions and prohibitions on the importation and the exportation of goods, how they can import or how they can export. So all the provisions are given in the Customs Act. So guys, please watch the video till the end or listen the video till the end to gain your knowledge about the Customs Act 1962. So in this video, we are going to see chapter number 14A, settlement of cases. In this same, there are sections from 127A to section 127L. So very important section in the Customs Act if your goods are seized or confiscated by the customs officer. This act will come into force. So this chapter is very important, settlement of cases. In the same, the chapter 14A containing sections 127A to 127N inserted by the Finance Number 2 Act 1998, 21 of 1998, section 102 with effect from 1st August 1998. So settlement of cases. The chapter is come into force from 1st August 1998. So in the same section 127A, there is definitions. Section 127B, application for settlement of cases. Section 127B, application for settlement of cases. Section 127C, procedure on receipt of an application under section 127B. Section 127C, procedure on receipt of an application under section 127B. Section 127E, omitted. Section 127E, omitted. Section 127D, power of settlement commission to order provisional attachment to protect revenue. Section 127D, power of settlement commission to order provisional attachment to protect revenue. Section 127A, power and procedure of settlement commission. Section 127A, power and procedure of settlement commission. Section 127A, power and procedure of a settlement commission. Section 127G, inspection etc. of reports. Section 127G, inspection etc. of reports. Section 127H, power of settlement commission to grant immunity from prosecution and penalty. Section 127H, power of settlement commission to grant immunity from prosecution and penalty. Section 127I, power of settlement commission to send a case back to the proper officer. Section 127I, power of settlement commission to send a case back to the proper officer. Section 127J, order of settlement commission to be conclusive. Section 127J, order of settlement to be conclusive. Section 127K, recovery of sums due under order of settlement. Section 127K, recovery of sums due under order of settlement. Section 127L, bar on subsequent application for settlement in certain cases. Section 127L, bar on subsequent application or settlement in certain cases. Section 127M, proceedings before settlement commission to be judicial proceedings. Section 127M, proceedings before settlement commission to be judicial proceedings. Section 127N, application of certain provisions of Central Excise Act. Section 127N, applications of certain provisions of Central Excise Act. So these are the section 127A to section 127N in the chapter 14A, settlement of cases. So very important chapters these in the Customs Act 1962, and the sections are also very important. So you have to listen these videos again and again to understand the Customs Act 1962, to understand the chapter, yeah, to understand the sections. So guys, section 127 in the same, there is given definitions. So in the clause A, bench means a bench of settlement commission. Clause B, case means proceedings under this act or any other act for the levy, assessment and collection of customs duty pending before an adjudicating authority on the date on which an application under subsection 1 of section 127B is made, provided that when any proceedings is referred back by any court, appellate tribunal or any other authority to the adjudicating authority for a fresh adjudication or decision, as the case may be, then such proceeding shall not be deemed to be a proceedings pending within the meaning of this clause. Clause C, chairman means a chairman of the settlement commission. Clause D, commissioner investigation means an officer of the customs or central excise officer appointed as such a commissioner to conduct inquiry or investigation for the purposes of this chapter. Clause E, member means member of the settlement commission and includes the chairman and vice chairman. Clause F, settlement commission means customs, central excise and tax settlement commission constituted under section 32 of the Central Excise Act 1944, first of 1944, and clause G, vice chairman means a vice chairman of the settlement commission. So these are the definitions in the 127A definition of the chapter settlement of cases. Section 127B, application for settlement of cases. In the same subsection 1, any importer, exporter or any other person hereinafter referred to as the applicant in the chapter may, in respect of a case in relating to him, make an application before adjudication to the settlement commission to have the case settled in such form and in such manner as may be specified by rules, and containing a full and true disclosure of his duty liability which has not been disclosed before the proper officer, the manner in which such liability has been incurred, the additional amount of customs duty accepted to be payable by him, and such other particulars as may be specified by rules, including the particulars of his dutiable goods in respect of which he admits story levy on account of misclassification, undervaluation, or inapplicability of exemption notification or otherwise, and such applications shall be disposed of in the manner hereinafter provided. Provided that no such application shall be made unless clause A, the applicant has filed a bill of entry or a shipping bill or a bill of export or made a baggage declaration or a labor or declaration accompanying the goods imported or exported through post or courier, as the case may be, and in relation to such document or documents, a show cause notice has been issued to him by the proper officer. Clause B. The additional amount of duty accepted by the applicant in his application exceeds 3 lakh rupees, and the applicant has paid the additional amount of custom duty accepted by him along with interest due under section 28AA, provided further that no objection shall be entertained by the settlement commission under this subsection in cases which are pending in the appellate tribunal or any court, provided that no application under this subsection shall be made in relation to goods to which section 123 applies, or to goods in relation to which any offense under the Narcotic Drugs and Psychotropic Substances Act 1985, 16 of 1985 has been committed, provided also that no application under this subsection shall be made for the interpretation of the classification of the goods under the Customs Act 1975, 51 of 1975. So, Section 127B application for settlement of cases, Section 127C procedure on receipt of an application under Section 127B, Section 127C procedure on an receipt of an application under section 127B. In the same subsection 1, on a receipt of an application under section 127B, the settlement commission shall within 7 days from the date of receipt of the application issue a notice to the applicant to explain in writing as to why the application made by him should be allowed to be proceeded with, and after taking into consideration the explanation provided by the applicant, the settlement commission shall within a period of 14 days from the date of the notice by an order allow the application to be proceeded with or reject the application as the case may be, and the proceedings before the settlement commission shall abate on the date of rejection, provided that where no notice has been issued or no order has been passed within the aforesaid period by the settlement commission, the application shall be deemed to have been allowed to be proceeded with. Subsection 2. A copy of every order under subsection 1 shall be sent to the applicant and to the Principal Commissioner of Customs or Commissioner of Customs having jurisdiction. Subsection 3. Where an application is allowed or deemed to have been allowed to be proceeded with under subsection 1, the Settlement Commission shall within 7 days from the date of an order under subsection 1 call for report along with the relevant records from the Principal Commissioner of Customs or Commissioner of Customs having jurisdiction, and the Commissioner shall furnish the report within a period of 30 days of the receipt of the communication from the Settlement Commission, provided that when the Principal Commissioner of Customs or Commissioner of Customs does not furnish the report within the appropriate period of 30 days, the settlement commission shall proceed further in the matter without the report of the principal commissioner of customs or commissioner of customs. Subsection 4. Where a report of the commissioner called for under subsection 3 has been furnished within the period specified in that subsection, the settlement commission may, after examination of such a report, if it is of the opinion that any further inquiry or investigation in the matter is necessary, direct for reasons to be recorded in writing the commissioner investigation within 15 days of the receipt of the report to make or cause to be made such further inquiry or investigation, and furnish a report within a period of 90 days of the receipt of the communication from the settlement commission on the matters covered by the application and any other matter relating to the case, provided that where the commissioner investigation does not furnish the report within the appropriate period, the settlement commission shall proceed to pass an order under subsection 5 without such report. Subsection 5. After examination of the records and the reports of the Principal Commissioner of Customs or Commissioner of Customs received under subsection 3 and the report, if any, of the Commissioner investigation of the Settlement Commission under subsection 4, and after giving an opportunity to the applicant and the Principal Commissioner of Customs or Commissioner of Customs having jurisdiction to be heard either in person or through a representative duly authorized in this behalf, and after examining such further evidences as may be placed before it or obtained by it, the Settlement Commission may, in accordance with the provisions of this Act, pass such order as it thinks fit on the matters covered by the application and any other matter relating to the case not covered by the application, but referred to in the report of the Principal Commissioner of Customs or Commissioner of Customs and the Commissioner Investigation under subsection 3 or subsection 4. Subsection 5A. So the Settlement Commission may at any time within the 3 months from the date of passing of the order under subsection 5 amend such order to rectify any error apparent on the face of the record, either suo moto or when such error is brought to its notice by the jurisdictional principal commissioner of customs or commissioner of customs or the applicant. Provided that no amendment which have the effect of the enhancing the liability of the applicant shall be made under this subsection unless the settlement commission has given notice to such intention to the applicant and the jurisdictional principal commissioner of customs or commissioner of customs as the case may be has given them a reasonable opportunity of being heard. Subsection 7 is subject to the provisions of Section 32A of the Central Excise Act 1944, first of 1944. The materials brought on record before the Settlement Commission shall be considered by the members of the concerned bench before passing any order under subsection 5 and relation to passing of such order. The provisions of Section 32D of the Central Excise Act 1944, first of 1944 shall apply. Subsection 8. The order passed under subsection 5 shall provide for the terms of settlement, including any demand by way of duty, penalty, or interest, the manner in which any sums due under the order under the settlement shall be paid, and all other matters to make the settlement effective, and in case of rejection contain the reasons therefore, and it shall also provide that the settlement shall be void if it is subsequently found by the settlement commission and that is it has been obtained by the fraud or misrepresentation of facts, provided that the amount of settlement ordered by the settlement commission shall not be less than duty liability admitted by the applicant under section 127b. Subsection 9. Where any duty, interest, fine, penalty payable in connection of an order under subsection 5 is not paid by the applicant within 30 days, 30, of the receipt of a copy of that order by him, the amount which remains unpaid shall be recovered along with interest due thereon as the sum due to the central government by the proper officer having jurisdiction over the applicant in accordance with the provisions of section 142. Subsection 10. Where a settlement becomes void as provided under subsection 8, the proceedings with respect to the matters covered by the settlement shall be deemed to have been revoked from the stage at which the application was allowed to be proceeded with by the settlement commission, and the proper officer having jurisdiction may, notwithstanding anything contained in any other provisions of this act, complete such proceedings at any time before the expiry of 2 years from the date of the receipt of the communication that the settlement became void. So this is the procedure after receipt of an application under section 127B for settlement of cases. Section 127E is omitted. Section 127D, power of settlement commission to order provisional attachment to protect revenue. In the same subsection 1, where during the pendency of any proceedings before it, the settlement commission is of the opinion that for the purposes of protecting the interest of the revenue, it is necessary so to do, it may by order attach provisionally any property belonging to the applicant in such manner as may be specified by rules. Subsection 2. Every provisional attachment made by the settlement commission under subsection 1 shall cease to have effect from the date the sums due to the central government for which such attachment is made are discharged by the applicant, and evidence to that effect is submitted to the settlement commission. So, section 127D, power of settlement commission to order provisional attachment to protect revenue. Section 127A, power and procedure of settlement commission. Section 127A, power and procedure of settlement commission. In the same subsection 1, in addition to the powers conferred by the settlement commission under chapter 5 of the Central Excise Act 1944, first of 1944, it shall have all the powers which are vested in an officer of the customs under this act or the rules made thereunder. Subsection 2, where an application made under Section 127B has been allowed to be proceeded with under Section 127C, the Settlement Commission shall, until an order is passed under Subsection 5 of Section 127C, have, subject to the provisions of Subsection 4 of that section, exclusive jurisdiction to exercise the powers and perform the functions of any officers of customs and central excise officer as the case may be under this act or in the Central Excise Act 1944, first of 1944, as the case may be in relation to the case. Subsection 3. In the absence of any express direction by the Settlement Commission to the contrary, nothing in this chapter shall affect the operation of the provisions of this Act insofar as they relate to any matter other than those before the Settlement Commission. Subsection 4. The Settlement Commission shall, subject to the provisions of Chapter 5 of the Central Excise Act 1944, first of 1944, and this chapter have power to regulate its own procedure and the procedure of branches thereof in all matters arising out of the exercise of its powers and of the discharge of its functions, including the places at which the benches shall hold their sittings. Section 127G, inspection etc. of reports. No person shall be entitled to inspect or obtain copies of any report made by the officer of the customs to the settlement commission, but the settlement commission may, in its discretion, furnish copies thereof to any such person on an application made to it in this behalf and on payment of such fee as may be specified by the rules, provided that for the purposes of enabling any person whose case is under consideration to rebut any evidence brought on record against it in any such report, the settlement commission shall, on an application made in this behalf and on payment by such person of such fee as may be specified by rules, furnish him with a certified copy of any such report or part thereof relevant for the purpose. Section 127H, power of settlement commission to grant immunity from prosecution and penalty. So Section 127H, power of settlement commission to grant immunity from prosecution and penalty. So in the same subsection 1, the settlement commission may, if it is satisfied that any person who made an application for settlement under section 127B has cooperated with the settlement commission in the proceedings before it and has made a full and true disclosure of his duty liability, grant to such person subject to the such conditions as it may think fit to impose immunity from prosecution or any offence under this act, and also either fully or in part from the imposition of any penalty and fine under this act with respect to the case covered by the settlement, provided that no such immunity shall be granted by the settlement commission in cases where the proceedings for the prosecution for any such offence have been instituted before the date of the receipt of the application under section 127B. Subsection 2. An immunity granted to a person under subsection 1 shall stand withdrawn if such person fails to pay any sum specified in the order of the settlement passed under subsection 5 of section 127C within the time specified in such order or fails to comply with any other condition subject to which the immunity was granted, and thereupon the provisions of this act shall apply as if such immunity had not been granted. Subsection 3. An immunity granted to a person under subsection 1 may at any time be withdrawn by the settlement commission if it is satisfied that such person had in the course of the settlement proceedings concealed any particulars material to the settlement or had given false evidence, and thereupon such person may be tried for the offence with respect to the immunity was granted and for any other offence of which he appears to have been guilty in connection with the settlement, and shall also become liable to the imposition of any penalty under this act to which the such person would have been liable had no such immunity been granted. So section 127H, power of settlement commission to grant immunity from prosecution and penalty, is also very important in this chapter. So guys, that's it in this video. from section 127I to section 127N. We are going to see in the next video. So guys, please listen these videos again and again to gain knowledge about the Customs Act 1962. And if you like my video, please share it with your friends who needed this knowledge, and also expand your knowledge about the Customs Act 1962. Thank you for watching till the end.